Let's move it right. Accepted to U of A.
Yes, thank you very much.
Out with
Senate will come back to order. We will go back to Senate bills. We are taking up Senate Bill 187.
Senate Bill 187 by Senator Irving to amend the composition of the Arkansas Medicaid Drug Utilization Review Board to include physician assistants.
Senator Irvin, you're recognized.
Thank you, members. It just adds physician assistants to the composition of the Arkansas Medicaid Drug Utilization Review Board. Happy to take any questions. Appreciate a good vote.
Any questions for Senator Irvin? Senator has left the well. All right. Anyone wish to speak against or for? Senator has closed. Any objection to rolling the vote? Madam Secretary, please roll the vote.
Boyd, Bryant, leave. Caldwell, Clark, leave. Crowell, Davis, Dees, Dismain, Dotson, English, Flippo, Flowers, Gilmore, Hammer, Hester, Hickey, Hill, Irvin, Blake Johnson, Mark Johnson, King, Letting, Love, McKee, Murdoch, Payton, Penzo, Petty, leave. Rice, Scott, Stone, Stubblefield, Sullivan, Tucker, Wallace.
Any senator wish to change his or her vote or who did not vote? Seeing no one, please cast up the ballot. By a vote of 32 yea, 0 nay, Senate Bill 187 passes. Please transmit to the House. We will now take up Senate Bill 207.
Senate Bill 207 by Senator Hammer to amend the law concerning initiative and referendum petitions to require a canvasser to disclose that petition fraud is a Class A misdemeanor and declare an emergency.
Senator Hammer, you're recognized.
Thank you, Madam Governor. Members, there are 5 bills that are going to be before you, and I'm speaking on Senate Bill 207. I want to make one statement that will be applicable to all of them for the sake of time, and also to leave plenty of room for questions on the 5 bills that I'm presenting to you today. With regards to Act 207, each part of the petition fraud is a Class A misdemeanor punishable by almost a year in prison. Canvassers are tricking thousands of Arkansans each year into signing petitions that they have already signed, cannot legally sign, or accidentally committed other acts of fraud. Largely, this is because people do not see the parking lot petitioners as serious government documents. And what this bill does is help to address and to fix this issue. That is regarding Senate Bill 207. There was plenty of testimony in the committee the other day, which most of you have probably heard about, and there were a significant number of people for and significant number of people against. There was actually a significant number of people that were for that were not able to sign up, and because of the process, when the vote came to a conclusion, there was equal opposition and there was equal support for these bills. Two entities that are supporting these bills are entities that we, for a long time as a majority, have supported and have presented reasonable reasons as to why these bills should be passed in order to address the issues that we are witnessing within the circulation of petitions or referendums. There are a few points that I want to make that are applicable to this bill as well as the bills that will follow. First of all, these bills have been thoroughly vetted by the Attorney General's office, the Attorney General, and the team in its entirety. They are all vetted to be constitutionally sound and not violate the Constitution. Secondly, they are ready to defend these bills should it be that they would end up in court. I think that is a statement or statement within itself that the Attorney General is ready to not only to defend these bills, but also has reviewed these bills. Secondly, there's an argument that is being circulated along with a lot of other rhetoric as far as these bills being restrictive. These bills are not restrictive. What these bills are is they provide safeguards or guardrails. And the reason why you need guardrails is because there have been plenty of accidents along the way, and you want to put some guardrails in place in order to provide for the safety of those that will travel that way in the future. We have found through testimony that has been given in committee that there are plenty of examples of people that have been abusing the system, manipulating it, finding loopholes, and doing other things in order to seek an advantage. The third thing I'd like to point out is that there are those that are saying this takes away the rights of the people. I do not understand, nor do I subscribe to that line of thinking, considering that one of our responsibilities as legislators who are elected by the people, of which there's a majority of us in here that are represented by a vast majority there of like-mindedness, that it is our responsibility to make sure that when citizens are approached and asked for their signature, that it is being done in the most secure and also addressing issues of the past that show that we have flaws that need to be addressed. The last thing I would like to point out is this, that we have seen over the years an increasing outside interference with our petition process, but also with the referendum process. And these laws that are going to be presented to you today, beginning with 207, are intended to increase or to look at the outside interference that is coming into our process. I will say on a personal level, I don't know that I've ever received the number of calls from outside this state regarding these bills, and I always raise the question, why is it that so many people outside of the state are interested in what we're doing inside the state, especially when you look at the amount of money that's being poured in from outside the state in order to dictate what we do within the state when it comes to referendums that are presented as well as the petition process. So for all of these reasons are why I'm presenting these 5 bills. I trust your good judgment. I trust your strength. I trust your courage. And I'm ready to answer questions on Senate Bill 207, Madam Governor.
Thank you. Senator Hammer, any questions for Senator Hammer on Senate Bill 207? Senator, seeing no questions, anyone wish to speak? Senator Dees, do you have a question? Senator Dees, you're recognized for a question.
Thank you, Madam Chair. And I don't intend to ask questions on each one of the 5, but it would be helpful for maybe framework for all 5. If you could help me answer our state's direct democracy process. Not every state has this. And in my quick research, I think it may be 18 or 19 states that have something similar to that we do. So it's in the minority that has a process like this. I think I would just love to understand maybe some of the framework and intention behind these bills to put me at ease. Would the phrase or the concept of would it be accurate to say that our Constitution shouldn't be able to be amended easily? Would you agree with that phrasing?
Yes, I definitely agree with that, and that's why all these bills are withstanding the scrutiny of the Attorney General having reviewed. And I did not mention, but I will now, that I've worked closely hand in hand with the Secretary of State's office, who is the front line for receiving complaints. I think what we are finding that drives the necessity of these bills, the number of complaints and evidences that have been presented as to how the actual constitutionality of what we have currently is being undermined and being eroded away, especially by those of outside interest or those that are looking for the loopholes around the Constitution. So these bills are intended, and more than intended, they are directed to close some of those loopholes and to bring greater accountability for those that currently are abusing the system, as based on the testimonies that have been given and the things that have been presented to the Secretary of State as to why they would like to see these bills passed.
And as the last follow-up, would you say that with the passing of these bills, that it strengthens the voice due to the accuracy of the process? Was that a fair assessment?
No, I think that's 100% spot on. I think that's what a majority of people are failing to see that are contacting us, because they're listening to the voice of just a couple that are trying to direct the conversation. And the value in what we're about to do here is that we are putting those safeguards and those guardrails protected. So at the end of the day, at the end of the discussion, when everything is said and done, what we have to walk away from this event from is saying, have we done what we are supposed to do to protect the integrity of that signature that has been asked for, but also has been given on a document that is going to be part of a permanent record? That signature is as valuable as any other signature that there is. Thank you.
Any other questions for Senator Hammer? Seeing no other questions, anyone wish to speak against? I see Senator Tucker, you're recognized to speak against.
Thank you, Madam President. I'm just looking around to see if Senator Hammer's friends are still here. I don't love coming down here. Can I just start with that? I don't love coming down here, especially against someone who I respect and admire as much as I do, Senator Hammer. Now, if Senator Flippo were running a bill, I might walk down here with a little bounce in my step, but not Senator Hammer. And you know, a lot of times I come down, I do have a job to do, and I appreciate sincerely y'all listening when I do come down here. And sometimes when I come down, I have philosophical issues I want to raise, and sometimes it's particular things with language. For the most part today, I'm going to keep it at a pretty high level, philosophical level. I really appreciated something Senator Payton said last week, that he wants to see the context that laws and Bible verses are in. That's why he goes to the chapter and verse and goes back to look. And I started when thinking about these bills with as big picture as you can possibly get, and that's with the Constitution of the state of Arkansas. This is the document that creates our state. Article 1, it establishes literally the boundaries of the state of Arkansas. Article 2, it enumerates our individual liberties: freedom of speech, freedom of religion, right to bear arms. Article 3 is a right to vote. Article 4 establishes our branches of government. Mr. Tree reminded me recently that in the Constitution, we don't actually call them branches, we call them departments. Those are the first 4 articles. Article 5 is the legislative department. It comes first. Article 6 is the executive department. Article 8 is the judicial. Legislative department comes first in our 3 branches of government. Article 5. So now I'm focusing in on Article 5. The Senate, the body we all love and serve in, that comes in Section 3. Section 3 of the legislative department. What's Section 2? Well, that's where the House of Representatives is established. Well, what comes before the House and the Senate? And that is the other group of lawmakers we have in Arkansas, and that is the people. That's the people. And it says very clearly in Article 5, Section 1, the people reserve to themselves the power to propose legislative measures. The first power reserved by the people is the initiative. The second power reserved by the people is the referendum. Now, when you have 2 groups of lawmakers There's an inherent conflict between the two. The two groups, again, are the legislators and the people. Because if one group has all the power, then the other has none. And when the people enacted Article 5, Section 1, they foresaw this. They knew about this conflict. And they put extra provisions in this article to address that. If you're the governor, now it didn't have anything to do with the current governor, this was passed in 1920. If you're the governor and the people pass a law, sorry, governor, you can't veto it. If you're the legislature and the people pass a law, you can't amend it with a simple majority. It takes 2/3. And then there's a special provision in the Constitution, and it's titled Unwarranted Restrictions Prohibited. And this is directed right at us. And it says, no law shall be passed. That's us. No law shall be passed to prohibit any person or persons from giving or receiving compensation for circulating petitions, nor to prohibit the circulation of petitions. This language is important. Nor in any manner interfering with the freedom of the people in procuring petitions. We can't pass any laws that do that. And so what have we done? Every legislative session since 2013, we have passed laws to make the petition process more difficult. Every single session since 2013. I think one of the reasons that we've done that is because the legislature, I'm talking big picture here, conflates two ideas, mixes two things up. And that is that there are two parts of this process. One is the signature gathering part, where we decide if something's going to be on the ballot, and the other is where the people ultimately vote on it. When you sign a petition to put something on the ballot, you are not voting for that to become law. You are not voting for that to become law. You are saying, I believe this is a decision that should be made by the people. Those are not the same things. I wasn't going to address this, but Senator Hammer mentioned the outside influence in the petition process. And I just want to address that. A lot of rules on the people that we don't impose on us. How many of y'all have worked with someone from outside Arkansas on a bill? Should we not be allowed to do that? Should every registered lobbyist be an Arkansas citizen? Otherwise, we're allowing out-of-state influence on the laws that we pass on this group of lawmakers. What if we had to gather signatures before we filed a bill? What if we had to check people's driver's licenses before they signed before we could file a bill? We're putting a lot of restrictions on one group of lawmakers without taking a look at ourselves. Now, Senator Hammer has talked about integrity of the election process. Senator Dees, you talked about accuracy. These are valid, legitimate goals, right? I hesitate to use analogies when I come down here, but I'm going to do it. You know what else is a valid, legitimate goal? Making sure that our Kansans are not injured or killed in car accidents. That's a valid goal. And I know what we could do to make sure that doesn't happen. We could put a four-way stop sign at every intersection in Arkansas. If we do that and people obey the law, we'll have 0 car crashes, 0 injuries, 0 deaths. But there's a reason we don't. It's because it would make the process way too difficult. So here we have a situation where we know people will die, literally, because of our decision not to put four-way stop signs at every intersection. But we make that decision as a society because we also decide there's something else on the other side of that. People have to be able to get around. So what's on the other side of this? Again, we have those legitimate concerns. What's on the other side of this? Something that's very important, and that is the people of Arkansas to get ballot measures on the ballot. And we're worried about one harm, which is that maybe there's an invalid signature, but we are guaranteeing the other harm, which is that the people can't get ballot measures on the ballot. And at the end of the day, what are we really worried about? What is the evil we're fighting against? Again, not on the vote, on the petition process. The ultimate evil, the ultimate concern is that maybe something gets on the ballot with only 88,000 signatures instead of 90,000 signatures for a constitutional amendment, or 68,000 signatures instead of 70 for an initiated act. At the end of the day, the people are the ultimate backstop when they vote on Election Day in November, which is a separate part of the process. 2 more points before I sit down. One is, I think we use too many emergency clauses down here. Emergency clauses affect, do you know where they're addressed in the state constitution? Right here in Article 5, Section 1. And the reason that this is where they are is because they inhibit the people's ability to put a referendum on a bill that we pass. And so when we are passing a bill that will inhibit inherently the people's ability to put something on the ballot, and then we're putting an emergency clause on there that inhibits their ability to put a referendum on this, we need to be very careful about that. And all 5 of these bills have emergency clauses. I think there's a separate reason, even if you like the bill, to vote against the emergency clause for that reason. The last thing is, do the people support these restrictions on the ballot measure process? I can tell you, I've been down here a minute, and I don't want to have recency bias, but I think this is a bill I've heard more on than any bill in my legislative career. Maybe when I was in the House, there was a gun bill that came through in 2017. But I think it's number 1 in the Senate. And I've gotten exactly one message in support of these bills. It was a message I gave it to Senator Hammer. Everything else has been opposed. Now, I understand that's not exactly a representative sample, but I know what is a representative sample. I didn't mention in the list of bills that we passed since 2013, we also sent out a referred constitutional measure in the last couple cycles, not in 24, but in 20 and 22. In 20, 55% of the people voted against it. In 22, 60% of the people voted against it. Now, you can't have 60% of Arkansans vote against something, just to put things in stark political terms, without a whole lot of Republicans voting against it. I don't believe the people support these measures that restrict the ability of getting something on the ballot. Now, all the harms that have been cited in committee and on the floor, people signing twice, already against the law. People being misled into what they're citing, already against the law. Every single harm that's already been cited, is already against the law. If there's a problem we have, it's with enforcement of the current law, not with lack of laws on the books. But every single time we pass one of these laws, when you look at them cumulatively, it really puts a major chokehold on the people's ability to get things on the ballot. And I mentioned this 2 years ago on a bill that Senator Dotson ran. But the reason I know that people don't like these bills cumulatively is because we are a populous state. And that is why our state motto is Regnant Populus. The people rule. And if we keep passing these bills, we need to change our motto to Regnant Imperium. The government rules. Because if the people, the first branch of lawmakers that we have under the Arkansas Constitution, can't make their own laws, then the government does rule. So I'll be voting no on this bill and any other bill that comes through this chamber that restricts the people's ability to get something on the ballot.
Thank you, Senator Tucker. Any senator wish to speak for? Any other senator wish to speak against? Senator Scott, you're recognized to speak against.
Thank you, Governor. Colleagues, I rise today again in strong opposition to Senate Bill 207 because it is yet another unnecessary barrier designed to intimidate and discourage Arkansans from engaging in the democratic process. Let's be clear, fraud is already illegal, and those things are already cited in the law, like Senator Tucker said. Every citizen has the right to participate in gatherings, in the signing of ballot measures, petitions and understand that dishonesty carries consequences. We all know that. So why require canvassers to deliver a warning about criminal penalties if the law is already well established? Because the goal isn't to prevent fraud, it's to scare people away from participating in direct democracy. In my opinion, Senate Bill 207 disproportionately impacts marginalized communities. And as a Black woman and a minority in this chamber, I'm going to always speak up for my community, who have faced generations of voter suppression tactics disguised as reforms, from literacy tests to poll tax to voter laws. We have seen the strategy before, and this is nothing new. So we can't ignore the historic parallels that we're facing. Minority communities have fought too hard for a seat at the table and to have a right to shape policies that directly impact our lives. And this bill truly threatens to push us back. Let's also remember that the ballot initiatives process is one of the purest forms of democracy, in my opinion. It allows the people, not just politicians, to set the agenda. Time and time again, when citizens unite to push for change, whether it's raising the minimum wage, expanding health care, or protecting our natural resources, special interest groups have tried to shut them down. Senate Bill 207 is just another attempt to stifle the grassroots activism and silence the people in Arkansas. We are a better state when everyone has a voice, no matter who they are. We are a stronger democracy when people feel empowered, not intimidated, to participate in the democracy process. I urge my colleagues to reject this bill and stand up for Arkansas, where every citizen can play an active role in shaping our future without fear, and without barriers, and without intimidation. And with that, I ask you to vote no on this bill.
Thank you, Senator Scott. Any senator wish to speak for? Any other senator wish to speak against? Seeing no one, Senator Hammer, you're recognized to close.
Thank you, Madam Governor. Just to address a couple quick points. Number one, back to the primary issues, take it back to the core, take it back to just the basic principles. Number one is that our Attorney General has reviewed these bills, and as far as being constitutional, they are constitutional. He is ready to defend them. I don't think that our Attorney Governor's office would put their reputation on the line unless they had reviewed them and felt with full confidence that they have met the constitutionality, number one. Number two, with regards to anything that would be perceived as restricting or making harder, I do not subscribe to that line of thought. And the reason I don't subscribe to that line of thought is because of the testimony that was given yesterday from individuals who are following exactly what is being asked when it comes to the petition process and when it comes to honoring the intent of the legislation with regards to the petition process, that they had given evidence across the state of situations that had occurred where it appeared and it showed that there were those who were not following, yes, even the present laws. And so these in fact, what I think it will do is make sure that every one of those voices that are represented in every one of those signatures on those forms will have been held to the highest standards and given the greatest respect of integrity as far as the process to preserve that every signature counts, just like every vote counts, and you can sign it knowing that it is going to be honored exactly that way. And with that, appreciate a good vote.
Thank you, Senator Hammer. Senator has closed. Before we begin the roll call, Madam Secretary, are there pairs at the desk to announce?
Yes, we have a pair at the desk. Senator Clark, yes. Senator Tucker, no.
Madam Secretary, please call the roll.
Boyd? Yes. Bryant? Leave. Caldwell? Clark? Yes. Crowell? Crowell? Yes. Davis? Dees? Dismang? Dotson? English? Flippo? Flowers? Gilmore? Gilmore? Yes. Hammer? Aye. Hester? Aye. Hickey? Yes. Hill? Aye. Irvin? Aye. Blake Johnson? Aye. Mark Johnson? Aye. King? No. Letting? No. Love? No. McKee? Aye. Murdoch? No. Payton? Yes. Penzo? Penzo? Petty? Leave. Rice? Scott? Stone? Stubblefield? Stubblefield? Sullivan? Tucker? No. Wallace?
Any senator wish to vote who did not vote or who wishes to change his or her vote? Senator Penzo, present. Any other senator? Senator Stubblefield, yes. Any other senator? Seeing no other senator, please cast up the ballot. By a vote of 25 yea, 7 nay, 0 not voting, and 1 present, Senate Bill 207 passes and the corresponding emergency clause is adopted. Please transmit to the House. We will now take up Senate Bill 208.
Senate Bill 208 by Senator Hammer to amend the law concerning initiative and referendum petitions, to view a canvasser to request photo identification before obtaining a signature and declare an emergency.
Senator Hammer, you're recognized.
Thank you, Madam Chair. I'll dispel with opening comments, go right to the thrust of what the bill is about. This bill requires voter ID for petition signing. The Arkansas Constitution calls a voter's signature on a petition their vote. In Arkansas, we believe in voter ID, but fail to apply it here where it is needed. Only registered voters should be voting for their signatures or with their signatures, and only Arkansas residents should be voting with their signatures. Last year, the medical marijuana amendment had over 4,500 duplicate signatures. The cause of these duplicates are unclear, but many are likely caused by someone signing their own name, then someone else, a family member, friend, coworker, etc., signing their name again. And we have no way to prevent this, and that's why the idea required by this bill will be the same as what's required to vote. I'll be glad to take any questions.
Questions for Senator Hammer? Senator Love, you're recognized for a question.
Y'all are trying to limit my voice. All right. So, Senator Hammer, are they checking for the signature on my ID? Say for instance, someone, a canvasser comes to me. Are they checking for the signature with this bill? Are they required to check for the signature? Is that what you're saying?
If a canvasser cannot verify the identity of the potential petitioner, the canvasser shall not obtain a signature from the potential petitioner. This is intended to make sure that if you sign your name, that is you by showing that form of ID, which is nothing less than what we expect when we go to the polls or for other matters as well. So it's to assure that that person, to eliminate me saying, I am Senator Love and I sign my name without presenting some ID that would not be able to be verified. And that's why 4,500 signatures on the medical marijuana ones were not honored, because of the duplication. And some of that could be, I can't see this honestly being by accident as much as I can by intent, but it is intended to make sure if you sign it, I'm just asking, is this you?
Okay, so I guess you kind of answered my second question, but now, were those signatures thrown out? Did you just say that those signatures were thrown out, even though they were duplicative?
I think they would have been thrown out because they were duplicated signatures, which means that somebody either signed their name twice, or maybe they determined that somebody signed somebody else's name. I really don't have, that is my understanding. I'll put it that way.
Okay, all right, thank you.
Thank you.
Any other questions for Senator Hammer? I'm sorry, Senator Murdoch, you're recognized.
Yes, just a question, as nonsensical as this is to me, to even stand before you to even question you, give you the moment to even answer the question. How do you even think that this could be policed if this bill, the canvassers is out? How do you even enforce this?
I think part of the enforcement, which will be brought back up tomorrow, I think part of the enforcement mechanism is it is as much to give people a level of comfort or security that if you are being asked to sign something, that you present that form of ID. And the reality is, you and I both know that as far as somebody standing there and watching that happen is not going to be realistic. But the expectation that I want to make sure, it's almost like protecting me as much as it is anybody else, because what if my name appears on a ballot that somebody else said, I'm just going to sign Kim Hammer's name? I would want to know that whoever's gathering that signature has had a requirement in order to make sure that if my name is being signed, that's actually me, by seeing a proof of identity. Because if I put my name on that form and then they ask, can I see it? And it's not that, then that signature gatherer should not take that. Now, we all know that it'll be punitive. Eventually they would be caught. But I think part of what this does is protect it on the front end, but hold accountability on the back end.
And you stand before us and you do not see the argument that so many have made against this, the number of phone calls, the number of inquiries that you've received and others, as how this is an inhibitor and a prohibitor from people being a part of the process. You think that you honestly believe that you're helping the process by what you're doing?
I think it is helping.
Proposing.
I'm sorry?
By what you're proposing.
If I didn't, I wouldn't be standing up here, number one. Number two, this is no less than what we expect when people go to vote at the poll. And the question was asked in committee, I think it was a valid question. Is the strength of the vote on a petition as strong as the strength of the vote at the voter box? And I think that it is, because people are out asking people for their signatures in order to get something done. I want to know, if I'm against that everything has been done to make sure that they don't get the amount of signatures that they're asking for. If I don't agree with that petition, I want to make sure that they are being held to a high standard, that if somebody puts their name on there, then that name is really who they are, because they're showing that ID. It's as much to protect the person that is signing it for the petition as it is to protect the person who is signing against the petition, because there's a standard applied to both sides.
Any other questions for Senator Hammer on Senate Bill 208? Anyone wish to speak against? Anyone wish to speak for? Senator Love, you're recognized to speak against.
Thank you, Governor. You all, it's very difficult for me to sit back there and just listen to this conversation, because if we know that we don't want to do something, and I think Senator Hammer said it best out of his own mouth, if he's against a petition, that's not what this process is about. If you're for or against a petition, the process is to let the people's voice be heard. And so we shouldn't try to limit that. If you're for a petition, if you're for a measure or against a measure, it doesn't matter. It's about allowing the people to get a measure on the ballot. Now, here's the thing that just perplexes me, is that as a legislator, you can bring as many initiatives as you like. You don't have to go gather 88,000 signatures or 90,000 signatures. All you have to get is 51 votes to have that measure, sometimes 66. But the thing about it is, the scrutiny for the people is there. It's us. It is us that I worry about. We can bring as many initiatives as we would like without the complexity of what we're trying to put the people through. And then for us to say that, oh, all right, have an ID so that you can verify signatures. If somebody approached me in a parking lot and asked for my ID and I didn't know who they were, I'm not giving them my ID. I don't care how many clipboards they have in their hands. Because I have information on my ID that I may not want you to have. And so if I sign a petition, that's fine. Let me sign my petition and put the information they require on the petition. But for somebody to ask me for my ID, they approach me and ask me for my ID that I don't know, I'm just not sure that I would do it. And then lastly is that I think that we're trying to create a chilling effect on the whole process. And if that's our aim, if that's our goal, we're spot on for doing that. But I don't think that the people of Arkansas want to be silenced. I didn't receive one email in support of any of these bills. And for us to ignore that, I think it's a travesty. So I'll be voting no, and I ask you to vote no on these measures.
Thanks, Senator Love. Anyone wish to speak for or against? Senator Hammer, you're recognized to close.
Thank you, Madam Chair. Just a few follow-up thoughts. Number one, we can introduce as many as we want to, but only 3 get through. Why is that? It's just as important that the signatures that are being gathered are verified as being individuals that are allowed to sign that based on what the laws say, both those that have been passed in the past and those that are being passed currently. Number 2, I think the fact that it is brought up that I'm going to show my ID to somebody in the parking lot. I think that speaks to the credibility why we need these bills is because there's a lack of trust within the system as far as people feeling confident when they do that. This is going to bring a higher level of confidence that if I want to sign that form and if I'm asking you to sign that form, I'm giving you evidence that I am who I say I am so that that vote is, or that signature is not stricken later as we have evidence that it has been in the past. And as far as letting the people's voice be heard, I think that we are continuing the process of letting the people's voice be heard. But what we're also making sure of is that when their voice is heard, it has been held to the highest standard and not lowering the standard. So with that, and the last thing I would say is this, I want you to just think about this. Where do you go that you're not asked to show your ID and is a signature on a form to represent the voice of the people, not as important as when you show your ID at the bank, when you cash a check, or when you go anywhere else that vital information is being asked for. This is as much about protecting the person who is signing it, whether you're for or against, as it is protecting the person who is taking it, whether they are for or against. It is a form of verification. And with that, I'd appreciate a good vote.
Thanks, Senator Hammer. Senator Hammer has closed. Madam Secretary, before we call the roll, would you announce pairs at the desk?
Senate Bill 208, Senator Clark, yes. Senator Tucker, no. Boyd? Yes. Bryant, leave. Caldwell? Clark, yes. Crowell? Yes. Davis? Dees? Dismang? Yes. Dotson? English? Flippo? Flowers? Gilmore? Yes. Got her no, didn't you? Okay. Hammer? Yes. Hester? Yes. Hickey? Aye. Hill? Aye. Irvin? Blake Johnson? Mark Johnson? King? Aye. Letting? No. Love? No. McKee? Aye. Murdoch? No. Payton? Yes. Penzo? Petty, leave. Rice? Scott? No. Stone? Stubblefield? Sullivan? Tucker? No. Wallace?
Any senator who did not vote, who wishes to vote, or who wishes to change your vote? I see Senator Penzo, yes. Senator Caldwell, yes. Any other senator? Seeing no other senator, please cast up the ballot. By a vote of 27 yea, 6 nay, Senate Bill 208 passes and the corresponding emergency clause is adopted. We will now take up Senate Bill 209. Please transmit Senate Bill 208 to the House. We will now take up Senate Bill 209.
Senate Bill 209 by Senator Hammer to disqualify signatures obtained by a canvasser under certain circumstances and declare an emergency.
Senator Hammer, you're recognized.
Thank you, Madam Governor. Right now, the Secretary of State reviews for sufficiency on the face of the petition itself, which might involve bad conduct investigations. This bill clarifies that signatures obtained criminally will be disqualified, and there's a period and exclamation point on that. The burden of the Secretary of State for determining criminal obtained signatures would be the preponderance of evidence, a standard much higher than on its face review of the petition itself, more likely than not. This gives the Secretary of State more security in making sure of securing the petition validity while holding him accountable in his determination. In a nutshell, if there's evidence that a collector of signatures has done something unlawfully, then all the signatures would be thrown out. I'd be glad to take any questions.
Questions for Senator Hammer? Senator Dees, you're recognized for a question.
Thank you, Madam Governor. Senator Hammer, on this one, I think I just had some concerns I'd love to get your thoughts on specifically. The word preponderance was a new one for me, and I had to look that up for definition. And it actually kind of concerned me a little bit because one of the definitions said importance. And so when I exchanged that word for importance, that concerned me that a future Secretary of State, current or future, would have the ability to decide if there was fraud or a significant amount of fraud based on their determination of importance. And so could you help me put me at ease, because this one I did have an issue with when I read it in that context. I may be in the wrong context, but I would love your thoughts of thinking it through in that definition, please.
Sure. A couple things. Remind the Attorney General's looked at this. Secondly, the staff attorney for the Secretary of State has reviewed this and been involved in this process. I'm not going to pretend to be a lawyer, but what I think I can give you in the way of reassurance is that on the basis of the preponderance of evidence, that would protect both those that have signed it in the event that the Secretary of State made an improper determination, but it would also protect the Secretary of State if there was validity to what they decided to do. And we all know that most, if not all, of these things end up in court, and it's going to be decided in the courtroom.
Senator Hickey, you're recognized for a question.
Thank you, Senator Hammer. And I heard what you said. You said all the signatures were going to be thrown out, and that was going to be my question. But I guess my thing is, and let's just for the sake of what I'm about to say, let's just say that Senate Bill 207 goes all the way through the process and passes. So then that will be a law regarding canvassing. So if we have a canvasser that, fails to read this notification, that this is a Class A misdemeanor on 8 or 10 people, and that's proven, but there was 2,000 signatures collected, we're going to throw out all 2,000 of those signatures?
That would be, yes.
That's the way I read it.
That you are reading it correctly. And go ahead.
Well, no, I've scored you last two. I'm struggling with that part of it. So I appreciate it. I just wanted to get clarity on that.
Can I give you a reason why?
Yes, sir.
If it is determined that that canvasser has broken the law in the obtaining of those signatures, the validity of all the signatures would be called into question as to how it was that they got them. Now, you and I both know that there'll be lawyers involved in that. There'll be a court decided in that. But if there's a bad actor out there, and that bad actor knows what the expectations are, and it is knowingly, or maybe that's not the proper legal term, but it is determined that that signature gatherer has acted in bad faith with the intent to violate the law, and that can be proven, then all those signatures would be disqualified.
Sure, and I can understand that reason, and it's just, I guess that one line on 27 where it says the Secretary of State shall not count signatures. So at that point, I don't even know how they could go back and do it if they wanted to. And again, I appreciate the explanation. Thank you.
Thank you.
Any other questions for Senator Hammer? Anyone wish to speak against? Senator Tucker, you're recognized to speak against.
Thank you, Madam President. I'll be quick. I wasn't planning to speak on this one. I just want to address one point Senator Hickey just raised. In the constitutional provision, Article 5, Section 1, it says that there shall be a cure if the Secretary of State determines a petition to be insufficient. All of these laws give, or several of these bills that are being passed today, give the Secretary of State unilateral authority to throw out signatures. No trial. As a matter of practice, we give sponsors a cure. Well, I'm glad they do. God bless them for doing it. But if we can put in law that they can throw them out, why should we put in law that they have to offer a cure as well? Especially if you're already doing it, what's the argument against including it in law? Now, they said several Secretary of States have done it and they don't foresee it changing, but we don't know who's always going to be Secretary of State. And you ought to have an opportunity to cure. I mean, that's fundamental to the process. It's not included in any of these bills. It's another reason to vote against them, in my opinion.
Thank you, Senator Tucker. Anyone wish to speak for? Anyone else wish to speak against or for the bill? Senator Hammer, you're recognized to close.
I would go to the basic premise of the intent of all these bills and what they are intended to do. If we are going to have people out there asking for signatures, there has to be 100% expectation that they are all complying within the law. I believe that there's allowances the way that it is written in order that if there should be a concern that has been expressed, it will be able to be handled. Again, it comes down to this, that if you have an individual that's out there, and this is going to be for the ones that are not acting in good faith in compliance with the law. If there's going to be somebody out there that's gathering signatures, and there were testimonies plenty in committee that gave evidence to the fact that this is happening, then those signatures will be disqualified. And I think it falls on the group or the entity that is going to be retaining, whether volunteer or hired canvassers, to go out and collect signatures, that they educate their individuals to the full extent of what the law requires. That will bring a higher level of integrity, and that will bring a higher level of purity and accountability for those that are both gathering signatures and those that are signing the forms as well. Thank you.
Thank you, Senator. Senator Hammer has closed. Madam Secretary, is there a pair at the desk?
Yes, Senate Bill 209, Senator Clark, yes. Senator Tucker, no.
Please call the roll.
Boyd? Yes. Bryant, leave. Caldwell? Caldwell? Clark, yes. Crowell? Crowell? Davis? Dees? Dismang? Dotson? English? Flippo? Flowers? Gilmore? Hammer? Hester?
Yes.
Hickey?
No.
Hill?
Yes.
Irvin? Blake Johnson? Mark Johnson? King?
No.
Letting?
No.
Love?
No.
McKee? Murdoch? Payton?
Yes.
Penzo?
No.
Petty, leave. Rice? Scott? Stone? Stubblefield? Sullivan? Tucker, no. Wallace?
Any senator wish to vote who did not vote? Senator Crowell, present. Any other senator wish to change his or her vote? Seeing no others, please cast up the ballot. By vote of 21 yea, 11 nay, and 1 present, Senate Bill 209 passes. The corresponding emergency clause is not adopted. Please transmit to the House. We will now take up Senate Bill 210.
Senate Bill 210 by Senator Hammer to require the signer to read the ballot title of the petition in the presence of a canvasser and declare an emergency.
Senator Hammer, you're recognized.
Canvassers may not accept a potential signer's signature until the signer has read the ballot title. Secretary of State's Election Department, pro-life organization, churches, members of General Assembly have gotten numerous reports of citizens being tricked into signing petitions that would never support. Instead, they are given misleading information such as calling an abortion amendment an amendment to preserve or to protect pregnant women. This will be enforced through the canvasser's affidavit that will be required to be signed. Only the ballot title summary will be required to be read prior to obtaining a signature. I'll be glad to take any questions.
Questions for Senator Hammer?
Just one.
Senator Hickey, you're
Thank you, ma'am.
recognized.
Thank you. So is this done after all the signatures are collected?
You go up and you ask somebody to sign their signature. The expectation, the bill requires a reading to make sure that they know what they are signing. There was testimony given yesterday of individuals, and we've received complaints about this, that people thought they were, and being told that they were signing a petition for one thing, when in reality it was misleading in order to get their signature. One testimony yesterday, for example, was of a pastor's wife who signed the abortion amendment, having been told it was going to protect women and other things, only to find out later.
I wasn't clear enough of my question.
Okay, sorry.
No, that was my fault, I'm sure. So the canvasser, whenever he turns in all of these signatures to the Secretary of State, that is the time that he's going to be required to sign this affidavit. Is that correct?
That's correct.
Okay. This is just my question in regards to that, and I didn't see it in here. Have we made any allowances that right towards the end or even during the process, if that canvasser was to die or become incapacitated in any way, is there not another option so that those signatures could still be counted? I mean, just in those, if we were to run into one of those situations, which, you know, this is life, so it could. So I guess that's what I'm asking. Would they just automatically not be counted because that particular canvasser has not signed that?
I do not believe that would be the case, Senator Hickey. That if in the event the canvasser was, and I'll use the word incapacitated, that it would disqualify those signatures from being counted. I will make you this assurance. This gets off the floor today before it gets down to the House. And if it needed to be amended, if that indeed is the case, I'll make you that commitment.
Okay.
But I do not think that that is represented in this bill, that that's what would happen.
Okay. So if we find, I want to make sure I understand. So if we find out between now and whenever it gets to the House that truly those signatures would not count, we're going to try to figure out some language then to make an allowance for those extraordinary cases like that. Is that correct?
Yes, because I think that would only be the fair and right thing to do, because that would not be the fault of those and those individuals that had signed.
Yes, sir.
That those signatures should not be disqualified. They should be honored and moved through the process.
Okay. Thank you for that.
Thank you.
Senator Boyd, you're recognized for a question.
Thank you, Madam President. Senator Hammer, I understood a constituent to tell me today that the entire ballot title had to be read, but what I understood you to say from the well was just the ballot title summary. So the point I understood from my constituent was it might be hundreds of words that had to be read. So when you say, if I understood you correctly, and we just say ballot title summary, is that much shorter, or do we expect that to still be hundreds of words? Could you give me some kind of, understanding of what that means? Thank you.
I'm going to go straight to the legislation, or straight to the piece of legislation, page 31 through 33. After reading the ballot title of the petition in the presence of the canvasser, or having the ballot title of the petition read aloud to him or her in the presence of the canvasser. And then if you flip over to the next page, as the canvasser knowingly accepts a signature when the person signing the petition has not read the ballot title of the petition in the presence of the canvasser, or the ballot title of the petition has not been read aloud to the person in the presence of the canvasser. I'll give you an example because somebody may be asking for it, so I pulled one. I will tell you, I think one of the things that this bill will help address is that we have found often that ballot titles can be prepared in a very lengthy way. And the expectation, and I believe what the bill requires, is I will read this to you. You will read aloud at what point that the individual signing has met that satisfaction. They would be able to sign it. But this is an example of a ballot title. I'm going to acknowledge that's a long ballot title. And yes, somebody brought out the question about how much time would it take to read. Well, one of the issues and one of the reasons that this bill is being proposed is because, as we heard in testimony yesterday, there are those that are asking for signatures that are misleading people into saying this is what it actually does, and this brings a higher level of standard. I do think that one of the things it's going to do is that when ballot titles are presented, this is my opinion, take it or leave it as a matter of fact or matter of suspicion. I think a lot of times ballot titles are written so as to be intentionally complicated, and that is just my opinion for what it's worth. But I think it's going to be something that's going to cause the ballot titles to be looked at a little bit tighter.
Any other questions for Senator Hammer? Oh, Senator Love, you're recognized for a question.
Thank you, Governor. So, Senator Hammer, if I'm understanding correctly, say for instance, you contact me, my signature is on one of the ballots. You contact me and and you ask me, did this person read the ballot title to you? And I say, well, you know what? I don't remember if they did or not, but I signed it. Okay. Could that lead to a preponderance of the preponderance that all the signatures that were gathered can then be thrown out? If we're taking your collection of bills in totality, if I say, even if you have a couple people that says, hey, I don't remember if that person read the ballot title to me or not, I signed it. Could that then lead to signatures, all the signatures being thrown out? Say this person gathered 5,000 signatures. Could that then be led to the throwing out of all the signatures just because me and maybe someone else doesn't remember? Because, it would set up that person would have then violated this law. Is that not correct?
I think what you're going to find in a situation like, or scenario like you are describing, that what is going to have to be determined is, was it a matter of oversight or was it a matter of direct intent? And that's what the bill is intended to do, is to remove or to bring to light those that are misrepresenting what the title or what the initiative is all about. And this is a pathway to bring clarity so that people would be required to read it, have it read to them, so that they would make sure that they are not being misled as far as what they are being asked to sign. I think it's going to boil down to a question of, did that signature gatherer, did that person just by matter of neglect or by intent, what was it that they did? I can't answer that question. I think that would be determined on a case-by-case situation.
Okay, does your bill discern in regards to the intent, or if someone just, they may have not read it, they may have read it, does your bill actually provide some sort of discernment in regards to the penalty?
I think that would be left up to what was determined as far as the investigation that would occur in the event that was called into question, which would be a pretty laborious task. I will acknowledge that, but it's intended, and the reason that we're asking that people read what is being handed to them is to address the issue of signature gatherers, which we had plenty of testimony about, that are out there and purposely not telling people what is in it.
Okay, thank you.
Thank you.
Any other questions? Anyone wish to speak against? Senator Tucker, you're recognized to speak against.
Thank you, Madam President. Thank you, colleagues. This will be the last time I'll come down here today on these bills. Senator Boyd, the answer to your question is the full ballot title has to be read, and that's for each time you collect a signature. I asked the Secretary of State's office in committee yesterday if they knew how long that would take. And Ms. Bellamy said that she read the ballot titles from the last session, last election, and one of them took 8 minutes. 8 minutes to read the title. And if you're doing a referendum, those titles are even longer. So let me see a show of hands. Who reads every word of the terms and conditions every time you check that box? Right? Senator Ervin, thank you. All right. Now, do some of y'all not do that because you think you have the ability or the right to sign without reading every time? And we're taking that right away from the people of Arkansas on these? Let me ask you this a different way. Let's say you're checking out at Walmart or Best Buy or wherever, and they say, okay, we know you want to buy that toothpaste, but before you check out, I'm just going to read these terms and conditions to you. It's only going to take 8 minutes. How many of y'all are just going to set it down and leave? So we are crushing the ability of people to gather signatures to put issues on the ballot. And I just want to address two other points that were raised. One about whether it's misleading, the way it's done now is misleading. First of all, if a canvasser misleads a person who is going to sign, that's already against the law, already against the law. Second, the full, not just the title, but the full measure has to be stapled to the sheet that you sign. So if you have a question about it, right now under the law, you can read it, the full, not just the title, but the full measure if that's what you want to do. And also, we've heard a lot of testimony and comments from people who were confused. They didn't know they were signing the abortion amendment. They were misled, right? So I've got a picture. This is the sheet that you sign, not the title. I've got a picture of the sheet that you sign. And in big bold words in all caps across the top, it says, an initiative petition to approve or reject the Arkansas abortion amendment. There is no lack of clarity under the law right now. And, we've also had conversation about whether ballot titles might be misleading. Well, that's the Attorney General's job. You can't get a ballot title through the Attorney General's office. They review every single one. It's in the law. We've passed that law. If the Attorney General believes the ballot title is unclear, he won't approve it for you to start gathering signatures. That's part of the process. Our Lieutenant Governor can testify to that because she had that job for 8 years. The reason why ballot titles are long is not to confuse people. It's because the Supreme Court of Arkansas has said if everything's not included, then people might miss something. So there are conditions put on by the Supreme Court rulings is why ballot titles are long. And so again, I go back to it. It's the cumulative effect of all of these together. Supreme Court has rules. We're doing all of these rules. In a silo, individually, maybe it's okay. But it's death by 1,000 cuts, and we are crushing the ability of people to put issues on the ballot.
Thank you, Senator Tucker. Recognized to speak for, Senator Mark Johnson.
Thank you, Madam President. I think I know how this bill is going to go, but I think it's important my colleagues think about this issue in a broader sense. We have a readability problem with initiative petitions. Those of you that ran for re-election last year, you probably got out and campaigning. You probably had people come up to you. I certainly did. I knocked doors and I had people ask me about two things. I felt like a public opinion pollster. One is they didn't like nonpartisan judges because none of the judges told them what they believed on anything. And the second was, I don't understand all these initiatives. And why is it when we have a bias in our current system that someone can come up with an 18-page constitutional amendment? There's only 482 words in the Bill of Rights, the first 10 amendments to the U.S. Constitution. Now that's being concise. That's writing it where people can understand it. Now, if you want to pass something, you want to slip something by the people, you're not going to do it in 482 words. You're going to make it complex. And for example, the recent late unlimited marijuana expansion amendment, it had buried in it a provision that would take away a provision in Amendment 7 that allows the General Assembly to, by a two-thirds vote of both houses, to amend the constitutional amendment. And many of you know, we're working on using that. We have an opinion from the Attorney General that says that that is a valid part of our Constitution. They didn't mention it. Now, I knew it was in there because I read the whole thing. And I had petitioners approach me, and when they do, I always engage them. I talk to them. And I asked these canvassers, did you know this takes away the authority of the General Assembly to, by two-thirds vote, to amend any measure passed by the voters? They said, oh, no, this is just about marijuana. So let's face it, folks. These out-of-state special interests, and none of them are all out-of-state, some of them are in-state, but they're special interests. They will do anything they can to confuse our voters. So it's the least we can do, and I think Senator Hammer made a very valid point in saying, is if you want to do an initiative, write your ballot title concise. Keep it clean so an ordinary person with an 8th grade education can read it and understand what it does. So I think this is not just a great bill in that regard. I think we need to go further. I think we need to do some more things to tighten this up to where, yes, you have a right to petition your government for redress of grievance. And under Article 5, you have a right. The people's reserved power is the initiative. But you don't get to throw this gobbledygook toward the people and then expect us to sit by and allow things that were never intended by the people that signed those petitions to make it into our Constitution. So because of those things, I want you to think about this important provision and appreciate a yay vote on this. Thank you, Madam President.
Anyone wish to speak against or for? Senator, you're recognized to close.
I want to bring clarification. One thing that the AG says ballot title is supposed to be minimum. You need to understand the petition. I think when you take a look at the petition that I held up, I don't think that it rises to that level, but nonetheless, it is what it is. The other thing I would like to mention is that I appreciate Senator Tucker getting up and sharing the opposing view, because I think it's part of a good deliberation process, but I also want to express publicly that I'll appreciate when he brings a bill that he's going to bring regarding that these initiatives need to be up on the website so that everybody can read them and understand them before they are asked for their signature. I think that's a good thing, and I think that this adds to that, and that we're just making sure that people know what they're signing and that they have a well-educated perspective on it if they read it. Thank you.
Senator has closed. Madam Secretary, before we call roll, would you announce pair at the desk?
Pair at the desk, Senate Bill 210, Senator Clark, yes. Senator Tucker, no.
Madam Secretary, please call the roll.
Boyd, Bryant, leave. Caldwell, Clark, yes. Crowell, Davis, Dees, Dismang, Dotson, English, Flippo, Flowers, Gilmore, Hammer, Hester, Hickey, Hill, Irvin, Blake Johnson, Mark Johnson, King, Letting, Love, McKee, Murdoch, Payton, Penzo, Petty, Lee, Rice, Scott, Stone, Stubblefield? Sullivan? Tucker? No. Wallace?
Any senator who does not wish to vote or wish to change your vote? I see Senator Boyd, yes. Senator Kroll, yes. Any other senator wish to vote or wish to change your vote? Seeing and hearing no other, please cast up the ballot. By a vote of 22 yea, 10 nay, and 1 not voting, Senate Bill 210 passes. The corresponding emergency clause is not adopted. We will now please transmit Senate Bill 210 to the House. We will now take up Senate Bill 211.
Senate Bill 211 by Senator Hammer to amend the law concerning initiative petitions and referendum petitions to require a canvasser to submit an affidavit before signatures can be counted and declare an emergency.
Senator Hammer, did you want to make a motion on the,
Yes, ma'am. I just want to make sure I understood. Did you take the position that the emergency clause on the last bill failed?
that is correct because it only received 22 votes.
Okay, thank you. I'd like to make a motion that we expund. Go ahead.
Middle of a roll call. Do it after we do.
Yep. Yep. We have already taken up Senate Bill 211, and so
Okay.
we can go back and take that up after Senate Bill 211.
That'd be fine. Thank you.
Senator Hammer, you are recognized to present Senate Bill 211.
Thank you, Madam Chair. Senate Bill 211, the Honest Canvassing Act, the Petition Protection Act. Right now, the Secretary of State is mostly bound to an honest face review rather than a review of canvasser conduct. This bill adds a layer of protection against canvasser fraud by having a canvasser swear under oath that they have followed all the laws while canvassing. This also allows the canvasser to have a simple good faith protection by being able to fall back on their own sworn statement if they are accused after a good faith mistake. This does not add an extra sworn statement like the one on the petition parts already. That is a statement to knowledge that those signatures are truthful. This is a testimony of their own conduct. I'll be glad to take any questions.
Any questions for Senator Hammer? Senator Hickey, you're recognized for a question.
Yes, just apologies, Senator Hammer, and clarification. The question I asked about the death of the canvasser, that actually pertained to this bill. I had my bills mixed matched. So my question to that was the same, and we are going to make sure that we have that clarified in the House, correct?
Yes, I'll make sure that's